Let us now move on and look at the remedies for illegality. Generally, the courts will not enforce a contract that compels unlawful conduct or immoral activities. Contracts that are illegally formed cannot give rise to rights and obligations. This is due to the operation of the legal doctrine of extirpe causa non oritur actio, which is Latin for "from a dishonorable cause an action cannot arise." This means that sometimes even the innocent party has no remedy. Recall, we discussed the case of Mahmoud Ispahani, and in that case there was a statute prohibiting the sale of linseed oil without a license. The buyer did not have a license, even though the seller did, and the seller was completely innocent in this scenario. However, the contract was illegal as formed, and therefore it was void, and even the innocent seller was not able to obtain a remedy. Generally, there's three types of remedies or consequences that we need to consider. First, there's enforcement. Recall the case of St. John Shipping and Rank. Rank tried to avoid paying the freight charges on the basis of illegality, because St. John Shipping had overladen their ship. However, this was not the type of illegality which would render the contract void, and hence, the contract stood and Rank had to pay for the shipping charges. So, this is a case of enforcing the contract. In Archbold Freightage and Spanglet, the issue concerned a shipment of whiskey. The plaintiffs had employed the defendants to carry this shipment from A to B. The defendants used a vehicle which had something called a C license. It did not have an A license. In order to carry goods for reward, it needed to have an A license. The defendants knew this, however the plaintiffs did not know this. When the shipment was stolen, the issue of the initial contract between the plaintiffs and the defendants came up. The question was whether that initial contract for carriage of those goods was illegal under statute. Clearly, the contract involved a behavior which was prohibited under the statute, namely transporting goods with a vehicle without the requisite license. The court held that while the behavior was prohibited by statute, the contract itself was not prohibited by the statute. Thus, the contract was not void, and it was in fact enforceable. In Saunders and Edwards, the parties had reached agreement for the sale of an apartment. However, in order to save on the stamp duty payable, which is determined by the price of the apartment, they agreed to reduce the price of the apartment and inflate the price of the fixtures, fittings, and furniture. Thus, this was an agreement to defraud the revenue. Later, the plaintiff brought a case which was unrelated to the defrauding of the revenue, which related to the garden which was part of this property. The plaintiff was not happy with that. The question arose whether the plaintiff was barred from bringing this claim because of the illegality of the original contract. The court decided that the garden issue, and therefore the claim being brought by the plaintiff, was not connected to the other issue, which was the agreement to defraud the revenue. The court recognized that this was not an easy decision to take. On the one hand, it felt that it was not right to lend a hand to a party, in this case the plaintiff, who had been involved with a contract tainted by illegality. On the other hand, the court also felt that it should not invalidate every agreement at the first indication of illegality. In particular, the court was guided by a comparison of the initial illegality, defrauding the inland revenue, and the garden issue. It felt that the plaintiff's loss was disproportionate to the illegality, and therefore the court felt that the plaintiff deserved a remedy. We've already discussed the case of Mahmoud and Isfahani. Here, enforcement was not possible because the contract was illegal as formed. In Alexander and Rayson, the parties had agreed on the leasing of an apartment. Again, in order to save on taxes, the parties agreed that the official rent would be lower than what the flat would normally bring in terms of rent. However, there would be a separate payment for so-called services. When the tenant did not pay all the rent, the landlord sued for arrears in rent. It was held that since the contract was void for illegality, the landlord was not able to recover. In Strongman and Sincock, the defendant, had employed builders to refurbish his house. The work was such that it required a license for the work to get done. Sincock, the landlord, promised to get the license. The builders went ahead and did their work. It turned out that Sincock had never gotten the license. Sincock then refused to pay the builders on the basis that their contract was illegal. The builders were therefore not able to sue upon the contract, which was void. However, they were able to recover damages nonetheless because of the defendant's promise to get the licenses. In essence, this was a collateral undertaking by Mr. Sincock. These cases show us that even where there is illegality, sometimes the contract may still be enforceable, at least by the innocent party. Secondly, we look at restitution. Restitution in this context means putting the parties back into their original state. We recall that in Parkinson and College of Ambulance, Parkinson had donated £3,000, expecting to be awarded a knighthood. When he was not awarded a knighthood, he tried to reclaim his £3,000. Of course, the contract at issue was tainted with illegality. Specifically, there was corruption in public office. The contract was void and not enforceable, so there was no restitution. In Tinsley and Milligan, there was restitution in the sense that Miss Milligan was able to recover her part that she had put into the house. Recall, this was the case of the two ladies who bought the house together, but it was only in the name of Miss Tinsley because both ladies had come up with a plan by which they were going to claim Social Security, which was only possible if one of them did not have property ownership, and that was Miss Milligan, and they were to share the proceeds from that. So their contract was an illegal one. Nevertheless, the courts awarded restitution and Miss Milligan was able to recover her part. When we talk about severance, what we mean is that a part of the contract is severed, cut off from the rest of the contract. Recall that in Nordenfelt and Maxim Nordenfelt, there was a restraint of trade. Nordenfelt was restrained from manufacturing guns and ammunitions of the type that he'd been manufacturing before for 25 years, and from entering into any competition with Maxim. This second part of the clause was held to be unreasonable. The fact that Nordenfelt was prevented from entering into any form of competition with Maxim. However, the first part was held to be reasonable, this being that Nordenfelt was prevented from manufacturing the types of guns and ammunitions that he had been manufacturing previously. So what the court did is it severed the second part. It took it out. It took out the part where it said that Nordenfelt could not enter into any form of competition with Maxim. So the first part was enforceable and the second part was severed. In Goldsole and Goldman, the issue was whether the jeweler who had sold his business could be restrained from opening another business and trading in the UK as well as overseas. Originally, he'd only traded in the UK, Therefore, that part was held to be enforceable, and the second part of the clause, the one that prevented him from trading overseas, was severed, because that went too far. Now, when the courts apply the rules of severance, what they do is they apply something called the blue pencil test. The blue pencil test is very simple. What it means is that the courts will not engage in rearranging the words and rewriting the contract. However, if the courts can use this proverbial blue pencil and cross out certain words of the contract and then read out the section without the crossed out words, if it still makes sense in terms of the content as well as in terms of the grammar, then the rules of severance may be applied. In other words, in Nordenfelt, for instance, the restriction of entering into any competition was a sort of add-on to the clause. Specifically, the clause read that Nordenfelt could not engage in this trade for the next 25 years, would not make guns or ammunition anywhere in the world, and would not compete with Maxim in any way. We do not need to rearrange those words in order to take out the last part. We can just simply take it out. The clause then reads, for the next 25 years, would not make guns or ammunition anywhere in the world. Full stop. So what we're doing is we're leaving out the last part, which had read, and would not compete with Maxim in any way. So this is the blue pencil rule. You're able to cross out certain words. You then read back the clause again. If it makes sense, both in terms of the content as well as in terms of the syntax, you can apply the rules of severance. However, if by crossing out the offending words, and by offending I mean the words that are demonstrative of the unreasonable restraint, if you cross out those words and suddenly the sentence no longer makes sense, or if it requires you to rearrange the words, then you cannot apply the rule of severance. So let us very briefly recap what we've learned. Basically, there's two types of illegality. There's illegality under common law and illegality under statute. When we talk about illegality under common law, we have identified 5 different categories of such illegality under common law. What all 5 categories have in common is that the contract runs contrary to public policy. The second type of illegality is illegality under statute. Here we identified 2 possibilities, either express prohibition under a statute or implied prohibition under statute. Express means that the statute prohibits the contract at issue, the contract itself. Implied means that the statute prohibits a certain kind of behavior, and if the contract involves such behavior, then the contract may be illegal under statute. But this really depends on the 2 tests that we learned about, which we apply in such instances. We also learned about restraints of trade. Those situations where a contract is in restraint of trade may mean that the contract is void, but strictly speaking, we do not speak of illegal contracts in this context. In terms of remedies or consequences, we learn about enforcement, restitution, and severance. Thanks very much for listening.